Hello everyone, myself Yusra Khan, co-convener of Lawlicious. Lawlicious is an organizing committee founded by Mr. Vivek Dixit, which provides knowledge about internships, debates, and moot court competition. It focused on promoting legal awareness through webinars and competition for students and scholars, which is beneficial for all law students. Now, I would like to introduce our keynote speaker, to our second day webinar, Dr. Indrajit Acharya Sir. Dr. Indrajit Acharya is currently working as a faculty member at multiple reputed institutions, including Umash Chandra College, University in Kolkata, and JIS University of Kolkata. He holds PhD in law and LLM contractual laws and BLLB with over 9 years of teaching and 9 years of legal practice experience. He has taught subjects like business laws, criminal laws, constitutional values, and international criminal laws at various colleges. Dr. Acharya has practiced law at Kolkata High Court and Alipur Court, specializing in both civil and criminal litigation. He has authored and edited multiple books on businesses and company law, published several research papers in national and international journals. He has been invited as a guest speaker at numerous seminars. Dr. Acharya is also an active member of Bar Council of India and other professional organizations. He is passionate about teaching, research and uphold the principle of law in both in his professional and the personal life. Up to you, sir.
Good evening, all of you. Am I audible?
Yes, sir.
Right. So, the given topic of our today is the comparison between the newly added BNSS along with the repealed CRPC 1973. So, before getting started, I would like to give you people an introduction, a brief intro about the need, about the necessity, why this change, why this repeal has taken place. The Indian legal system has long relied Code of Criminal Procedure 1970, a framework that is driven from colonial era. However, with the introduction of BNS, a new era of a new era of criminal procedure, I should say, is set to begin from 1st July 2000. The BNSS aims to overhaul and modernize the criminal procedure in India. It tries to address the existing challenges of the procedure, delays, low convictions rates, and inadequacy of adoption of technology. Along with, there are many things that was not very much clear in CRPC because of certain terminology that has been used in CRPC, because of certain choice of words, because of some lacuna that was there in CRPC. BNSS has tried to complete those lacuna or loopholes, which later on in our discussion I shall try to bring up to you. So let me share my PPT first with you all. Right. Is the screen visible to all of you?
Yes, sir.
Yes. Thank you. So, without wasting any further time, let's get started. First thing first, today I shall try to bring to you people the changes, the notable changes. There are many changes that has taken place in BNSS. I shall try to bring you people the notable changes that has brought about in BNSS and which was not there in CRPC. Right. So first thing first, the change that has been brought about, the most notable change that has been brought about in BNSS is section 15, which talks about special executive magistrate and the expanding authority of its. This provision basically has given the state government to authorize to appoint any police officer as special executive magistrate. We all have heard about the executive magistrate in our CRPC, types of criminal code and their power, basically under section 6 of CRPC. But there was nothing that was categorized as special executive magistrate in terms of CRPC. It was only executive magistrate that was mentioned over there. But this newly framed BNSS has given respective state government to empower to authorize any police officer, but the police officer should not be below the rank of SP, Superintendent of Police, to appoint any magistrate as a special executive magistrate, but along with executive magistrate. It is not something where only special executive magistrate will exist and the concept of executive magistrate has been abolished, has been repealed by the BNSS. It is not that. Executive magistrate is still very much there. Along with executive magistrate, a special executive magistrate has been appointed. This is number one. Number two, the role of executive magistrate that was there in CRPC has now given a wider power in terms of special executive magistrate. Executive magistrate that is still there with the given power of its, along with special executive magistrate, whatever the existing power that was there with executive magistrate, that remains the same, but the enhanced power, but the additional power is entrusted with special executive magistrate, which was not there in our very old CRPC, repealed CRPC. Now next thing, enhanced power of imposing fine, that is there in section 23. So previously, as I talked about, types of criminal code and power of criminal code under section 26 and 29, where the power of inflicting punishment under CRPC was mentioned. It was there that the first class judicial magistrate, which we commonly called as JM first class, it was of 10,000 rupees, but now it has been enhanced up to 50,000 rupees. Again, JM second class, judicial magistrate second class, it was of pecuniary punishment of 5,000 rupees. It was there, which has been enhanced up to 10,000 rupees right now. Similarly, uh, other classes of magistrate like JM first class, like executive judicial magistrate, sessions judge, they also have been entrusted with the power to impose community service. This concept of community service we already have talked about in our last session, that is in BNS, Bhartiya Sanhita, where a new form of punishment has been included in BNS, which was not there under section 53 of IPC, where the type of punishment has been mentioned. So it is a new form of punishment that is introduced by the BNS, and this BNSS has also reflected the same in terms of giving all kinds of judges, all kinds of magistrates, be it first class, be it second class, be it court of sessions, the power to impose community service as a form of punishment. Next, what was the need to change this amount of fine? The need to keep up the pace with the changing need and the financial condition of the society. Because of to have a safe standard, to have a modern standard in terms of inflicting punishment, in terms of inflicting pecuniary punishment upon the offender. That was the very need to enhance the power of inflicting fine from 10,000 to 50,000 and from 5,000 to 10,000. Next thing, section 35, subsection 7. Protection for the aged and infirm person. Whole new dimension, whole new concept introduced by BNSS. There was no such provision that was there in CRPC regarding this. Okay. This section 35 has talked about any individual who is an aged or senior citizen or an infirm person, he or she, if getting arrested for an offense which is punishable, which can be punished with less than 3 years, such infirm or aged person can never get arrested, can never put behind the bar without the permission or authorization of DSP. Minimum rank DSP, Deputy Superintendent of Police. So a prior permission of DSP is required before arresting any aged and infirm person. Okay, here I would like to mention one thing. The infirm person, not the aged, the infirm person, the incapable person, the crippled person, he or she can be aged less than 18, less than 60 years also. Need not necessarily be a senior citizen. Aged person, we all know it should be a senior citizen, but the infirm person need not necessarily be a senior person. He or she could be less than 60 years of age also, right? Uh, so again the question, what was the need? What was the objective behind insertion of this section in BNSS? The most important thing, the CRPC did not have any special provision, any special protection for the aged. So the aged citizens, like any father-in-law, like any mother-in-law, they were very vulnerable or susceptible in terms of dowry death, in terms of claim of dowry section 304B, in terms of cruelty 498A. If a daughter-in-law, lodges any FIR, then there was high probability, there was high chance that these aged father-in-law or mother-in-law could be taken into the custody by the local PS. So now they are getting a protection under section 35 subsection 7, whereby they cannot be taken to the custody without prior permission or approval of any police officer up to the rank of DSP. Next, again, a very good thing that has been introduced by our BNSS. Technological advancement. Technological advancement integrating modern tools. What does that mean? Simple two things. Electronic summon and electronic FIR. Section 63 and section 173. What does they mean? They mean a person need not to go to the local thana, local PS to lodge their FIR. So in past, we have seen on many occasion, on many a circumstance, this has happened that any person, he or she is very much afraid. He or she is very much afraid of lodging an FIR or going to Thana and lodge FIR. It could be for political reason. It could be for threat or coercion that local goons have given to him or her. It could be for the safety of her or his own body property. It could be for the safety of his or her own ward. Anyone, for granddaughter, grandson, it could be for anyone. So this BNSS has cleared all the air, has cleared all the doubts that was there in the mind of a suspected or proposed or supposed complainant. They have given them a clean passage. They have given them all clear air to go to Thana. So no need to go to Thana and lodge the FIR. Simply by means of electronic communication or technological communication, they can lodge FIR, which they are regarded, which they are termed as EFIR. This is a new sort of a thing that has been given under BNSS, and most important thing, these electronic concepts, this technological advancement have been authenticated, have been supported by the court of law of our. Okay, so no need to go to Thana and lodge FIR. If you were under some kind of threat, coercion, or anything like that, so be very bold. Need not to go to Thana and lodge FIR. Simply by clicking of technology, you can lodge the FIR. Okay. Number two, the concept of zero FIR. This is something that I would like to mention. That we all are aware of this zero FIR since the CRPC, but there was no express provision. There was no express mentioning under any section of CRPC what zero FIR is all about and how to launch this, how to carry forward this. There was very much an ambiguity in terms of zero FIR in CRPC. But BNSS have given them a clear signal, have given them a clear provision under BNSS. So now we are very much clear about what zero FIR is and how to deal with zero FIR. And no Thana, even though the cause of action did not take place within the jurisdiction of that Thana, no Thana, no police station can refuse to lodge, can refuse to take FIR from us. Again, I'm mentioning my own provision that section 154 of CRPC, section 154 of CRPC had given some sort of indication about zero FIR, but no clear provision was there in CRPC regarding zero FIR. Now, this BNSS, it allows for lodging of FIR, EFIR, with the requirement that the complainant signature is obtained within 3 days. Matlab, you can lodge the FIR by your own through e-means, but after lodging of FIR, you can go to, you matlab Thana will visit your place, Thana will visit your residential place and shall gather the requisite signature as a complainant of yours over the e-piece of paper, electronic FIR that you lodged by means of electronic technology. Okay, so again, after the lodging of FIR, you need not to go, you need not to visit the Thana to put your signature to verify, to authenticate the FIR you lodged. It is the duty of the Thana to come to visit your place, to come to your place and collect the signature of yours. And that too, there is a period of limitation that has been mentioned by Limitation Act, that is 3 days. Inside 3 days, the Thana will come and will collect the signature of yours over the FIR you lodged by means of electronic. Next, mandatory videography and forensic investigation under section 105 and 176. So there is another ambiguity, there was another matter of controversy that existed in CRPC. Okay? During spot investigation, during spot inquiry, क्या सर आप लोग ने तो कुछ किया ही नहीं, क्या सर आप लोग ने तो सही तरीके से इंटरोगेशन किए ही नहीं, इन्वेस्टिगेशन किए नहीं, उस जगह आप गए नहीं, वो प्लेस आप विजिट नहीं किए. This is a very go-to sort of allegations police used to face over the years in past. But BNSS has completely sealed, has completely locked all these lacunas, have clearly mentioned by section 176 that during investigation, videography is mandatory. Without submission of the videography footage, no investigation report can be validly submitted before any magistrate. Even the magistrate, at any moment of time while going through any kind of case, any kind of investigation or inquiry, they have to have the video footage with their custody. They can ask for from the IO, from the investigating officer at any point of कोर्ट ट्रायल ये आपके पास जो वीडियो फुटेज है इन्वेस्टिगेशन का वो आप सबमिट कीजिए. अच्छा, वन थिंग आई मस्ट से, दिस वीडियोग्राफी is for both police inquiry as well as judicial inquiry. Judicial investigation के लिए भी mandatory है, police investigation के लिए भी mandatory है. ऐसे नहीं कि only because of only time of judicial investigation the videography is mandatory. Even during police investigation, non-judicial investigation, videography is mandatory. So, along with this, forensic investigation, which we commonly known as expert opinion. In case of any expert investigation, चाहे वो postmortem हो, चाहे वो handwriting graphology हो, graphological activity हो, कोई भी forensic investigation, videography is mandatory for that purpose also. For that purpose also, it is very much necessary. So, why this was necessary? Why BNSS include all this? Very simple thing. Transparency, accuracy, integrity, and accountability of the investigating agency, investigating officer, and expert opinion. Okay, how much, how far accountable or acceptable your investigation is, we all must have an eye over it. This is our right to investigate this. This is our right to know how you people conducted your investigation. This is our right to know how an expert conducted, how an expert come to the opinion of his. Okay. Next, section 398, enhancing witness protection and streamlining trial. So, what is this? Again, a very old concept of lacuna that was there in CRPC. Witness protection scheme. Witness protection scheme. Whatever the witnesses, be it minor witness, be it adult witness, be it male witness, be it female witness, sometimes in respect of some cases, they felt some kind of fearness or afraidness कि मैं जाऊंगा, मैं बोलूंगा, स्टेटमेंट रिकॉर्ड करवाऊंगा, उसके बाद क्या होगा, अरे भाई वो लोग जो अगर मेरे पीछे पड़ गया तो मेरे को प्रोटेक्शन कर देगा, ना 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 ना, ये सब झमेले में मेरे को नहीं पड़ना है. आई डोंट वांट टू go to court. I don't want to put my name as plaintiff witness or as a defendant witness. I don't want to put my name. मेरा नाम मत लिखो. Fine. Now, BNSS has given it a clear mandate to all the respective state governments to provide a witness protection by means of their own state law. It will be their own state law. It will be their own state legislature by which they must frame, they must create a witness protection scheme to provide adequate protection to all the prospective witnesses. So, why again, why it was required, why it was inserted, why it was included? Because to ensure natural justice, fair trial, and higher conviction rate. Because we all know in our judiciary, in our trial system, because of lack of evidence, many a criminal are moving freely in our society here and there without getting conviction, without being put behind the bar, without getting due punishment up there. So, The conviction rate was very much lesser. So to increase conviction rate, to secure the witness, to seal the escaping of the offenders, BNSS has come out with this plan. Again, this was not there. There was no such comprehensive provision. There was no such comprehensive section that CRPC provided to us. Next, timeline for judicial processes. So, BNSS somehow has interfered. Statute, parliament, legislature has somehow tried to interfere within the judiciary also. How far? How come? So, they have set a strict time frame. They have given the judiciary a strict time frame for a fair trial process. It should be within 30 days from the completion of the argument. हम सभी को पता है कि after the submission of evidence, after the recording of statement of evidence, the argument starts. So once the argument is completed within 30 days, which could be extendable by 45 days on very exceptional sort of a case, not in case of any fast track court FT court trial. In normal prelims, maximum can be extended by 45 days. Within 30 days, the trial should be concluded by the judge. On certain exceptional cases, it can be enhanced up to 45 days. So, on a daily basis, every court has to keep their record very straightforward on a daily basis. What has taken place in today's date, what will take place in tomorrow's date, everything should have a clear picture there. So, to make the justice delivery system very swift, to make the justice delivery system very fast, for a first trial, for a very free and fair delivery of judgment, this provision has been included in BNSS. Next, this is very important to me. Change of certain words, change of certain terminology, removal of insensitive terms, removal of some archaic terms, right? For example, lunatic person. For example, person of unsound mind. Okay, these are the words that were very much there not only in CRPC, IPC. These are the words that are there in many a statute of ours. But at least BNSS has replaced, not tried, has replaced these words. They have inserted the words like intellectual disability, person with mental illness. They have inserted words which are very much in line with, synchronized with Mental Health Care Act of India 2017, where in CRPC they never tried to make any kind of parallel line with the mental health act. There was a very comprehensive amendment of CRPC that took place in 2019. बहुत सारे जन आप लोग बोलेंगे कि सर CRPC was of 1973, mental health that was of 2017. So how come it is be possible for CRPC to come out with the terminology which is in line with Healthcare Act? But to them, I have an answer. After the Mental Health Act comes into operation in 2017, in 2019, our very own CRPC had a very comprehensive amendment. Even in that amendment, there was no change of these insensitive words. Even CRPC not even tried for 1% to change these sort of words. Now, BNSS has again cleared all these doubts and ambiguities. The term like person with mental illness, the term like intellectual disability, these are very much in line. They are very much in connection with Mental Health Care Act 2017. So, in some procedural cases, in some procedures, BNSS has made some changes. Section 350 says, for example, proclaimed offender. It is a very go-to sort of a word for us. It is very much a go-to sort of a word for us in terms of criminology. A proclaimed offender hai bhai ko. What does the word proclaimed offender mean? Where is it been defined? Nowhere. Basically, it is sort of an arbitrary interpretation that the judicial personnel of ours were giving. They were coming out with the definition of their own, with the explanation of their own. It was completely man-to-man basis. It was completely an arbitrary basis. But BNSS has removed, has curtailed, has curbed this arbitrariness, because BNSS has clearly mentioned any accused where the punishment is of 10 years or more only can be declared a proclaimed offender. Any accused who is punished with offense of less than 10 years can never be called as an offender. So it has given a clarity, it has given a transparent picture कि किसको हम लोग proclaimed offender बोलेंगे और किन लोग. It was not there. Now the go-to case, the go-to court procedure of ours in terms of criminology, that is C case, criminal cases. Earlier in C case, the accused could have been discharged if the complainant, जिन्होंने complaint file किया है, was absent. Now this scope of the accused letting free has been completely shut. This door is no more open for the accused. के complainant absent है, उसको मैंने putting him under gunpoint, by letting him under fear, by putting him under any kind of coercion, I have stopped him from going to court. Whatever the complaint he has lodged, because of his absence, I shall be left free. No, the BNSS has completely shutted that door. It has given the complainant to be present before the magistrate within 30 days. Within 30 days from the date of the filing of complaint before the magistrate. This time frame was not there. If the complainant was absent, accused would have been left free, would have been discharged. Now, this 30 days of time period has been given under section 272 to the complainant, where after lodging of complaint, complainant can go to magistrate and be physically present over there and affirm or confirm the complaint lodged. So, the same thing is also applicable for withdrawal of suit. We all know that after lodging of suit, after certain point of time, we could have withdrawn. Compoundable nature of an offense. But before withdrawal of suit under BNSS, the victim must have been heard, must have been given an opportunity to represent his case. Why is he in a position? Why is he ready to withdraw the complaint? Why did he lodge the suit priorly? And what has made him to withdraw the suit? Okay, so without audio alteram partem, without giving him a chance to represent his ground, he cannot be allowed to withdraw the suit, withdraw the case. Right. As I mentioned, victim, even accused, has been given an opportunity of being heard in complaint cases. Audio alternate parties, both the parties must be heard. I say only victim will be given the opportunity to represent his case. Even the accused has been given the opportunity to represent his case in the complaint cases. Okay. So, as I mentioned, new proviso to section 223 of BNSS. Now, accused must be heard before cognizance can be taken complaint before magistrate. So, these are the two new dimensions. One is giving them the opportunity before withdrawing any complaint case. Another is to be present before 30 days after lodging of the complaint. Within the 30 days, they have to be present. So, this is from my end as far as today's session is concerned. It's a comprehensive sort of a provision that has been there in our CRPC. That was not there in our CRPC, but is very much there in BNSS. So hereby I am stopping my PPT, sharing of PPT. If any one of you have any kind of a question, may ask.
Thank you so much, sir, for your wonderful session. We have learned a lot from your session. Now, anyone have any doubt, then you guys can ask. I repeat, if you have any doubt, then you can ask. Everyone, if you have any doubt, then you can ask. Okay, thank you so much, everyone. Everyone will get the certificate after attending all the three webinars. Thank you so much.
Okay, thank you very much, all of you. So
Thank you
I'm
so much,
leaving for
sir.
today. So all of you meet again in the next class, in the next session, that is the
Thank you
next
so much,
Monday.
sir.
Thank you. Thank you.